Welcome to Ground Rules, Employment Law over your coffee break. My name's Pam Howland, and I'd like to welcome you to our episode on severance agreements today. Today with me, I've got Jennifer Walrath and Doug Plass, and we're going to dive in and talk a little bit about some of the big issues you might want to consider if you're thinking about giving departing employees severance agreements and some of the issues that we see in our practice with that. So, one of the most basic questions you need to answer when you're thinking through this is, why would I give someone a severance agreement? And when is the right set of facts that we should be thinking about when we have a possible situation where a severance agreement might come in handy? And I would say to that I think of severance and a severance agreement as somewhat of an insurance policy. If you have a high risk termination, maybe you don't have good documentation to show that you had a legitimate, non discriminatory reason for the termination. Maybe you have an employee who's coming off of some type of paid leave. Maybe they took FMLA leave. Maybe they have an ADA accommodation in place. If you have someone you're terminating who triggers some possible type of risk, that is when you want to be thinking about severance. Because to me, it's the one thing you can do as someone's walking out the door that gives you some certainty if they sign that agreement that you're not going to be hearing from them in 3 or 4 months with a claim. So severance and a signed severance agreement with the right language in it gives you peace of mind and a clean break with an employee who may potentially have some kind of claim. So Doug, Jen, what do you guys think? What comes to your mind as to the right scenario for severance?
Yeah, well, what's interesting to me is that, our perspective as employment lawyers is exactly what you just said. This is a tool to deal with risk. From a lot of employees and employers' perspective, that's not what severance is. It's more like something to reward being there for some period of time or to help the employee out when they're going to leave. So a lot of times when we're talking to employers about this, our first question is, what's the risk? And they have to kind of reorient themselves to think about it in this way. But I think in terms of what are the risky things, like, has this employee talked about bringing a claim? Has this employee made any complaints? Has this employee done anything like talked about that they felt like they had been discriminated against in any way? Um, have you gone through the ADA process with them, or have they talked about having a disability? Anything like that is going to be a situation where you might want to at least think about severance as an option.
Yeah, and I guess kind of going back to Doug's initial comments, there are some employers who have a formalized severance program and routinely pay severance. I think in this case, we're talking about employers who do not have something like that, and this would be perhaps an exception to the rule, so to speak. That this is something where you're thinking about providing someone with severance when that's not customary upon the departure of an employee. And what I would add to what Doug and Pam both have said is if you have an employee who, and we see this actually come up quite a bit, is, they might be surprised by the separation and be someone who is going to be very upset by that separation. Maybe they're a longtime employee. Their supervisor says they've never been a good employee. They've always done their job poorly, but for whatever reason, that never got communicated to the employee is maybe a common example. And that employee may be upset enough to do something about it if they haven't signed a severance. And they may fall into a risk category along the lines of what both Pam and Doug had talked about. So I think that's kind of the other sort of intangible, maybe fuzzier consideration. does this employee also seem like somebody who's gonna be upset and maybe want to take action to do something, and then there's a risk factor there that, just adds to the legal risk on top of the practical risk.
One easy way to think through whether someone poses a risk or not is hopefully when you're doing a termination, you're looking at that termination checklist, right? I mean, that is something that we talk about a lot is every time you're getting ready to pull the trigger on a termination, you should be weighing the risk for a number of reasons, right? Maybe, to see if you do have the documentation in place to show that there's a legitimate reason for the termination. But we have that checklist. We're happy to share that checklist with you. We use that checklist. And to me, that really is the starting place that you should be approaching every termination from is okay, we've got the risk factors here. And if you're seeing that a number of the boxes are checked when it comes to risk, then the question of should we consider severance should definitely come up. Doug hit some of the highlights, talking about accommodations and leaves and all that, but obviously the risk is longer. Really anyone in a protected class category could have more risk with the termination, just depending on the set of facts that are in front of you. For example, if you're terminating the only woman that works in a department of 5, maybe that woman is high risk, right? Because it looks like the only person in that class is being terminated. So those are a few thoughts on when you might be thinking about severance. I like Doug's point too. It is a good point. There are reasons that employers do it that don't necessarily have to do with the risk, but we are employment lawyers, so we're going to be talking about the compliance piece. So it's true. Certainly there are other reasons to do it as well. So, how about the amount that you need to offer if you're going to go down the road of giving a departing employee a severance package? That is a question we get all the time is how much do I need to pay them in order for that agreement to be enforceable at the end of the day? And so Doug, what are your thoughts? Doug's shaking his head because
Like
we do get that all the
the
time.
answer to that is, what do you think it's going to cost to get them to sign it? So it's going to depend on the employee. It's going to depend a little bit on the nature of their job. A lot of time you think about kind of some multiple of what their weekly pay is, right? And if it's somebody who's been there for a very short amount of time, maybe a couple weeks of pay is okay. If it's somebody who's been there for a long time and there's a lot of risk associated with it, it might be more like a couple of months of pay. Um, but it's going to be an individualized answer. There's not going to be a blanket answer for any one person. And something that Jennifer was just saying came to mind too. This idea, if the employee is going to be surprised by it, right? If they know it's coming and they've had some opportunity to prepare for it, it might not take quite as much. But if somebody's surprised and they're like, "Oh my gosh, what am I gonna do for the next few weeks or month or whatever? How am I gonna live?" This might be a way to incentivize them to just sign the thing and get it over with.
Yeah, and I was gonna say, I agree with everything Doug said, that it is variable, the amount. One sort of backup napkin, I guess, metric that often people use is sort of a week of pay per year of service. But I really do, I guess one point I wanna make is, in a situation where this truly is not just a thank you for your past service, to make sure it's very clear this is for additional new obligations. We have, for what it's worth, we have had some situations where people, claim it's like wages if you don't get paid the severance. There's this question of like, is severance wages or is it something else? And, I think it's appropriate where it is something else. We're getting a release and some other obligations from the employee, which I think we'll talk about here in a little bit, to just make sure that's clear in the agreement. But I will say, I think a lot of employers do kind of, starting place to come up with that number typically is some, uh, combination of years of service and their, weekly or annual compensation, and looking at those to get numbers to kind of start somewhere.
Yeah. Yeah, I don't think a court is gonna have some specific guideline they're looking at to see if you paid the right amount or not, and it really is a contract principle, right? Like, are they getting something? Is the employee getting something from you in exchange for giving up a potential claim? As Doug and Jennifer were talking, I was thinking, "Oh, the answer is more than a peppercorn." Isn't that's like what they teach you, like, from some old case in law school? I remember in law school being like, "What's a peppercorn?" Like, I don't know what that means, but I think it's just a contract interpretation, enforcement issue, and there is no set guideline, and as long as you can show they're getting something, of value in exchange for that release of claims, then you would probably be okay.
Importantly, something that they aren't entitled to already anyway.
It can't be you can't say, "Hey, we're gonna make sure you get all your wages and you get all your PTO paid out and, the sick leave bank, the policy says you're entitled to cash out." So, it can't be the stuff you're already gonna get, it has to be something different. That's a good point. So let's talk a little bit about provisions to include in a severance agreement. I'll throw out, to me, the most important thing is the release of claims to make sure you've got solid claim release language. Sometimes we'll have employers say, they'll call and they'll be like, "Hey, we fired someone and we gave them a severance payment and now they're coming back with this claim." And we're like, "Okay, send us the agreement." They'll be like, "Well, we didn't really get an agreement." And that to me is horrifying. Like, I would never give someone a check on their way out the door without getting a claim release. If you're going to go to the trouble of giving someone something more than what they were entitled to, get the claim release for sure. So to me, that's the starting point. That's probably from a compliance perspective, the most valuable thing to have in there.
I agree, and, I think, a lot of agreements include things like confidentiality of the agreement itself and sort of the lead up to it. That's pretty standard on both parties' part, but, and there sometimes are carve-outs for things like your, spouse or partner, tax consultant, things like that, people who kinda need to know for various reasons. That's something you might see in there. Um, and if you have an attorney help draw this up, you won't have to worry about it. But for people who are 40 plus years of age, there are additional provisions that must be included for setting out a particular period of time the employee has to consider the severance offer. And an allowance that even once they sign the agreement, they have a certain amount of time that they can revoke it. So those are sort of legally required provisions that just be aware that those are out there and a thing that should be included. And I guess the other thing I was going to mention is if you do have prior agreements with this employee that you want to survive signing severance, it's just a good idea to kind of make that clear. If you've got that, just keep those in mind, think about them and how you want to handle any other agreements that you might have already with the employee that predate the severance agreement.
Yeah, that I think that point we've learned over time because of different cases that have gone to court. But if you have language in your severance agreement that might be the type of language you put in other contracts, be very careful about that, saying this replaces any and all agreements that we previously have in place. Because, for example, if you have a non compete in place, maybe you don't want something becoming the only binding agreement that you now have. You want to make sure you're not going to negate some other important agreement you have designed to protect your business. So be careful about that one for sure.
Oh, and I had a few more. One thing a lot of employers seem to like are non-disparagement provisions. So some provisions saying the employee is not and the employer are both not going to disparage one another. You're going to want to try to have some language as to what that exactly means. I'm not never exactly sure, but try to put some bounds on that.
Just real quick, Doug, on the non-disparagement, that can be when it's hard for the employer. So another alternative to that sometimes is a neutral reference when someone calls for a job. So there can be alternatives, I suppose, to like if you're a large employer with 80 people plus hundreds of people, it's very difficult to say that not a single person who works for you will ever say anything negative about, this employee, especially if they don't know what happened. So in any event, there can be ways to work around that when you have a challenge just from the employer's perspective on complying with something like that.
Yeah.
But sorry to interrupt.
No,
Your
that
list.
was good. Thank you. And then, almost all of these have something where the employer is denying any wrongdoing. I think that's probably a standard thing that's always going to be in there. Sometimes there's some tax indemnification language in there as well. You might want to consider that in some cases.
And maybe explain a little bit like why, like how that comes up, because
So
that is a big deal. And most of the settlement agreements, I would say, that we negotiate once there is a claim floating around out there. So
yeah, I mean,
yeah.
severance is usually treated the same way as wages, and there is taxes taken out of it. Not always. But what indemnification would be, to the extent the employer's not going to take responsibility for your tax burden. And to the extent that the IRS is going after someone for unpaid taxes on this amount, the employer's indemnified as to that. Yeah. Another thing I see is return of property. That seems to always be an issue. It's a little tricky as to put that in the severance agreement sometimes, because what you really want is an acknowledgement that all property has been returned or will be returned, rather than having it hinge on the return of property, which can kind of complicate things somewhat as well.
Yeah, I have a few. So a couple of points before we move on to other provisions to include is we're in Idaho, right? So in Idaho, it's Wild West. It's kind of a free for all, not a lot of law. Some of those provisions that Doug was talking about, confidentiality, non disparagement, if you have offices in other states other than Idaho, you might not be able to put those in your severance agreement. I have seen some state law provisions that limit those in certain contexts. So be aware of that. A choice of law, again, we're in Idaho where it's the Wild West. So maybe you want Idaho to be your choice of law if you're an employer, probably, right? Especially if you have your office here. That is a good thing to clarify in your agreement. Like, what is the choice of law? Where would a lawsuit take place as well? Your venue provision. Those are good things to think through. You want that in your severance agreement for sure. So if things for some reason blow up on the back end, you've got that clarified. Another thing that we see in severance agreements is creative ways for an employer to cover the employee's healthcare benefits, maybe for a few months. Like there are ways you can include language. For example, if you've got a COBRA continuation obligation, if the employee elects it, there are ways you can word it in a severance agreement for an employer to pay that for the employee as part of the severance package. Sometimes that is very appealing to employees and might bring them to the table for severance, where otherwise they might not be that interested. So that's another good one to think through if you think that's going to be an issue. Yeah, I mean, sometimes we see non-compete non-solicitation confidentiality stuff maybe mentioned in there. Like Jen was saying, you want to be really careful if you've already got some type of non-compete, non-solicitation confidentiality provision. You might have a paragraph in there that says those are still in play or that address them in some way. Jen talked about the 40 and over language. That one is hugely important. And if you don't include that for someone 40 and over, you might have just given someone a payment and find yourself without a binding severance agreement, because that one has the potential to negate the enforceability of the agreement if you don't include those. So that one's really important too. So I think those are some of the key ones. I think those are good to think about, good to include. That 40 and over language, sometimes I'll have a party on the other side, um, maybe who takes a crack at drafting it. Maybe the employee's got a lawyer or something. And I can always tell if a non-employment lawyer drafts it because they don't include those. That's an employment law thing, super important to include. Okay, so a few parting comments. What do you guys think about, whether or not an employer runs a risk of setting some kind of precedent if they pay someone a severance? Is it, if you're an employer and you think a departing employee is high risk, are you setting some kind of precedent by offering one employee a severance agreement? What do you guys think about that?
I mean, I think that employers certainly think they are. That's we hear that all the time. Um, Especially public employers, I think. And I think that's because it's the information about the fact that there was the severance agreement is kind of more easily spread around. Um, yeah, I think it's a real thing, right? Um, you're gonna have to think about that. But I think that, if you're using this tool for only those things where you've identified there's actually real risk there, um, it's maybe less likely to be a problem, right? So you're not going to be denying it to someone else when there isn't actually risk.
Yeah, I'm thinking along the same lines as Doug. I think it's worth thinking about. I if you started using severance agreements as a tool and 10 years down the road, you have a departing employee who says, well, every single other person in my group got a severance when they left and I didn't. Could there be a claim? Maybe. That's sort of a legal risk piece of it. But like Doug was saying, just practically speaking, people hear things and then someone holds out their hand and says, well, I want my severance when I leave. So, I think it's worth thinking about it. How do you message it when you're making the decision, to really use it as a tool? Again, unless you have an established program, to use it and think through when it's appropriate to use it.
Yeah, I would agree with all that. And I would just say that you've probably, if you've tuned into other podcasts, episodes of ours, you've heard us talk about how expensive lawsuits are, the headache, the stress, the uncertainty. It doesn't take long if somebody brings a claim against you before you would be having the thought of, oh, geez, we probably should have, like, if there was an easier way to have made this go away earlier on, we should have done it. So, I mean, I definitely think if you're an employer, you're not going to hand out severance regularly. You want to, again, that's why you want to do all the front end stuff to make sure you've got the documentation and you can create, the defense you need, if something blows up. But there are situations where through no fault of the employer, severance does make sense. So I think, like they said, we're thinking about on a case by case basis. And I would certainly say I wouldn't foreclose thinking about it just because you're worried about creating some kind of precedent that you will pay out when somebody leaves. The other question we get sometimes is, what if you're an employer and you offer an employee severance, and one of those, that's a provision we haven't talked about, but actually is in the agreement, is that the employer is going to put in the agreement that the employee has the right to go talk to an attorney, right? So what if you give the employee the agreement, they read it and they say, "Oh, I'm supposed to go talk to an attorney." They take it to a lawyer, and then the next thing you know, the $10,000 severance payment that you offered, suddenly you've got an attorney demanding $20,000, right? What are the ramifications or the pros and the cons of offering severance in light of the risk of that? I would say, the same thing, that does that happen? Yes, that can happen. We've seen that happen from time to time. You certainly don't have to increase your offer. Then suddenly the employee finds himself, okay, I guess I've got a decision to make here because possibly they've got a lawyer telling them that the value of the claim's worth more than what you're offering. But again, I mean, I think that is the risk you run. But hopefully, if you're offering it to begin with, you've thought through the risk and you're willing to take it on.
Yeah, that was my thoughts as well. Really, was that yes, that could be a risk, but it may well be worth it, right? To find out if the person will accept severance. I mean, there's a reason why you're offering it. And even if an attorney comes in with a higher number, you might be able to negotiate something different. And like Pam was saying, you also could decide to not change your offer. It really is the max amount for whatever reason. And you are knowingly then deciding that you're okay with the employee may well file a claim. And that's the route that you are willing to take instead. So I guess I'll just say you have then more information to make your decision and go from there.
Yeah. Well, I'm sure that, an employee being talked into pursuing a claim by presenting a severance agreement to an attorney has happened, will happen. Generally, when you're offering severance, not only do you know there's risk regarding this employee, but it's pretty clear the employee knows that there's something going on, that they need, that they feel like they've been treated unfairly or something or another. So although that can happen, I don't think that's generally what happens. I think that, it does signal to the employee that you're taking it seriously, but it also signals the employee that you want to resolve it. So if they get counsel involved, that's what the counsel's going to be thinking about as well.
Yeah. Okay, that is the basics on severance agreements. I was just thinking as we were getting ready to sign off here, there are other topics. Maybe this is like part 2 on severance, but I was thinking about another question that comes up a lot is how the heck do we present severance? That's kind of its own separate issue. Maybe we'll take that on for another episode at a later date. But that's it for today on Ground Rules. Thanks for joining us. Just a reminder, we've got a whole host of resources here for training and compliance. We've got our Law for Leaders book, the roadmap every leader needs to follow to avoid claims and lawsuits, which is kind of a desk guide that's got a lot of the key employment law concepts in an easy to digest format. Also, don't forget, since we are talking about severance today, we can help you with your severance agreements. So that's part of our practice. We see those issues come up a lot. If you're needing an agreement or wanting to talk through that, give us a call. We're happy to help with that too. And we have our training platform. We do in-person training. We have some recorded content. Some employers have us do a little bit of both, in person to reinforce the recorded content, pretty much everything you need to get your supervisors trained, your leaders trained, basically the stuff you need to know to avoid claims and lawsuits. So keep that in mind. I also was just looking at our calendar, and as it turns out, September's coming up hot, and there's a lot going on in September. So we will be at the SHRM conference here in Boise on the 19th, presenting there, attending that conference. That's a great one to hit if you've got employment law issues and you want to learn more. That is always time well spent. And then on September 25th, we have a training we're hosting that's on how to conduct investigations. So if you do that in-house, or if you want to do that and feel more comfortable, we do a lot of workplace investigations, and we're going to share our knowledge with you on that. And hopefully you leave that training feeling good about it, knowing how to document it, what to ask, the key issues you need in order to put together a compliant workplace investigation. So that's it for today. We'll see you next time.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.